Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in our CV140466, Home Builders Association of Central Arizona versus the City of Surprise. Each side is allocated 20 minutes for argument. The appellant may reserve a portion of that time for rebuttal. If you wish to do so, you will need to keep track of the time using the podium clock, and keeping track is your responsibility. Out of respect for counsel, I'm going to ask that those in attendance make sure that cell phones are off or on vibrate. Counsel, be assured we have read the briefs, we have conferenced the case this morning, and we encourage you to keep that in mind as you present your oral argument so that you get the best use of your time. These proceedings are being recorded and will be posted to YouTube. It sounds more of a threat, like a threat every time I say it. As you begin your argument, please state your name and the party you represent. And counsel for the appellant, if you would.
Thank you, Your Honor. I am Timothy Lasota, representing the plaintiff appellant, Home Builders of Central Arizona. I have Will Fishbach with me, and I also have the director of the Home Builders, Ms. Connie Wilhelms, in the front row. So may it please the court, I would like to reserve 4 minutes for rebuttal, but I am mindful of the fact that it's my responsibility to keep track of that. So I wanted to start off by talking about how this case goes to the fundamentals of governmental power and limits on governmental power. And I say that because we have a law in place in the form of ARS 9463.05 that states when cities can collect impact fees and when they may not collect impact fees. That is the law at issue here. And at issue at this particular matter is, do we allow redress for a continuing violation of the law? You saw in the Surprises brief that they talked about, well, statute of limitations in tax refund cases can be very harsh. We're not asking for a refund. We have never asked for a refund. We are asking them to stop with an activity that we have alleged is illegal. So I think that this is not a tax that was collected. This is a tax that is being collected. So I think that's a critical distinction here. And one of the things that both the Sixth and the Fourth Circuits put it this way: the continued enforcement of an unconstitutional statute cannot be insulated by the statute of limitations. And I think that's clearly the law in Arizona. That's clearly the American system of justice, because it's one thing if we have something that happened in the past that, okay, well, they did an act, a singular act. They did something wrong, and after a certain amount of time we say, yeah, statute of limitations applies and you can't go back. But here we're talking about something they're doing all the time. They're collecting this fee that the legislature says they cannot collect.
Can I ask you a couple practical questions? First of all, why is Home Builders the plaintiff?
Your Honor, we're the plaintiff because we're the organization that represents individual home builders.
Have you ever paid a fee? Have you ever paid one of these development fees?
Your Honor, our members pay development fees, and the answer is no. The organization has not paid a fee.
I guess that's my question. What standing does Home Builders have to bring this? Why not just have one of your members as the plaintiff? And why not have one of your members file another case yesterday?
Well, Your Honor, I think we stand in the shoes of our members. I think we have organizational standing. In fact, the defendants here didn't even raise the issue of standing.
I understand, but to the extent that there is a valid limitations argument out here somewhere, the question is, so what? I mean, does it preclude anything? Let's say that Home Builders' action filed on January 14th is time barred. Does that really matter from the standpoint of practical enforcement of the law? You could have somebody else, one of your members, for example, bring another case the very next day, and there's nothing about the time bar that might have applied to your complaint that would be preclusive on anyone else who wanted to bring this cause of action.
Your Honor, the way I read the trial court's order is that anyone who was charged the fee over a year ago for the first time would be precluded. I mean, I don't...
You're saying that Are you saying that entities not parties to this lawsuit would be precluded by an order of the court in this case?
Well, the reasoning of the trial court, Your Honor, says that the statute of limitations begins to run the first time any of your members pay the fee. So presumably that would apply if, let's say, one of our members wanted to sue, and we'd have the same motion to dismiss. They'd be saying, "Well, you as a member paid the fee." I mean, most of our members have paid the fee since January of 2012 when this was initiated.
Counsel, I thought the trial court went out of its way to say it was only this plaintiff in this case on this claim that was barred. In fact, I thought the minute entry said that, and I'll read what I think it says, that another plaintiff might not be barred from bringing a declaratory judgment action to challenge the fee does not make assessment of the fee a continuing violation as to this plaintiff. I mean, I thought the trial court had done a pretty good job of cabineting the limited nature of the ruling.
Well, Your Honor, but the members would have paid the fee in many cases already. I mean, so they would be precluded under the same logic that if you've paid this fee, within the last year, you're out. You cannot sue, even though this is a continuing violation. But
and I want to hear a lot from you on continuing violation, because the briefs really focus on that. But the question was whether this plaintiff in this case brought a timely claim, not, and it didn't, I don't think, purport to bar other entities who were directly assessed from timely challenging that. And I just want to make sure we understand each other.
Judge, by the logic of the court's ruling, any member that paid this fee is forever, if they did not sue from within 1 year of paying the fee, they are forever barred from challenging this assessment. So,
but aren't they independently anyhow? I mean, if the limitations period is 1 year and they wait for a year and a half, they're barred even if this case didn't exist.
No, Judge, I don't think they are barred, because in this instance, we have a case in which this governmental entity is assessing this fee on a regular basis. If we look at the statute in question, 946.3.05, it says a city may continue to assess the fee. Right. That's the language the statute uses. So it's the act of assessing the fee. It's the act of saying, if you want a housing permit, you have to pay the fee. That's the violation of law.
But if that happens on day one, year one, and it's not challenged until day 180, year two, that's time barred, right?
No, it's not, because every single time they collect this fee under the continuous accrual rule, they are.
I want to get to that, but before we go there, without the continuous violation doctrine, you would agree that if you sue 18 months after the assessment, that's time barred, fair?
Oh, yes, Judge. If we were asking for a refund of something we paid in January 1st of 2012 and we sued 18 months later, we would not be able to get a refund.
Might you not do that if you get your declaration?
Your Honor, we don't have any plans to sue for a refund.
You believe that you could if you had such plans?
Well, I believe we could go back a year from the.
That's the limit on refunds?
I think, yes, I think that is the limit on refunds, Judge.
How about your members? Could they go back and seek refunds? They're the ones paying, right?
Yes, I think individually, Your Honor, if the court were to rule this is an illegal impact fee, I think they could get refunds, but they would be, on the refund side, I think they're clearly subject to the statute of limitations, because, I mean, pretty much all the cases we cited, when they talk in a refund stance, you cannot go back for, if you can only go back as far as the statute of limitations will take you back.
And let me ask you one more hypo then, and then I want you to get to the points that you want to address. But what if a builder is assessed the same assessment today? Can't that builder then challenge it within the next 12 months and have that claim be timely? I don't know about merits. Let's set merits aside. But isn't that a timely claim to challenge this process?
Judge, under the trial court's logic, if they've paid the fee over a year ago for the first time, it wouldn't be timely.
They pay it today. It's a brand new building, brand new house, there's no associational standing issue, so you don't have to worry at kind of the aggregate. You look at Sam Thumb, a builder. How about that? A bad hypo. Sam Thumb, a builder, and I get assessed today. Can't I challenge that in the next 364 days and have that claim be timely?
Your Honor, I certainly believe so.
So they are not then limited by the association with home builders?
If they haven't paid the fee, I don't know how they could be, but under the trial courts, I think it goes back to whether they've paid the fee or not.
Is payment of the fee even necessary? What if you had a citizen who's just generally opposed to the construction of public facilities in the city of Surprise, and as a taxpayer says the collection of this fee is illegal? It's driving up home prices, and I want to see it stopped. That person has never paid a fee. The statute of limitations wouldn't start to accrue.
Your Honor, I think there might be a standing issue, but
Well, that's kind of where I began today, because Home Builders has never paid a fee and is not, I don't know if you have an attorney-client relationship with any of the actual members of the association, but it seems that Home Builders is little more than my hypothetical person who's opposed to public improvements.
Judge, I think we clearly have organizational standing. As I said, it was not even raised below. I think we meet.
No, but the point I'm getting at is not to subtract from your standing, but rather to address accrual. I'm wondering whether the payment of the fee is really an essential element of this analysis at all.
Judge, I think it is an essential element, because every time they assess the fee, they violate the statute. The statute says they can only continue to assess a fee if it meets the requirements of 46.
Merits, yes.
Yes.
This is actually a softball. On the merits, sure, it's relevant that the fee may be a violation of the law. But when it comes to accrual, is the payment of the fee really the touchstone of the analysis? Or does the mere existence of the two conflicting, or allegedly conflicting laws, the city law and the state law, itself create the cause of action without the need for payment of the fee?
Judge, I think you could make an argument for that the fact that this law is in place creates a continuous accrual situation. But I think that whatever theory it is, I think it's clear that when you have a situation in which someone continues to do something that violates the law, you have continuous accrual. We've cited a number of cases for this proposition. Howard Jarvis out of California involved a user fee that violated Prop 82, said it had to go to the voters. They never sent it to the voters, and the city of La Habra says, well, you can't challenge this. You missed the statute of limitations. California Supreme Court says no. Every time they assess this, it's a new cause of action. The Texas Supreme Court ruled the same way on an illegal fee. Colorado Supreme Court, Rhode Island Supreme Court. The case of Henshaw. Let's talk about a case from 100 years ago in this state. It said you are not required to tolerate continued invasions of a right simply because you've tolerated them in the past.
How broadly, though, does that apply in Arizona? Because it seems to me that applies in trespass and nuisance cases, and it hasn't been applied, the continuing violation, it's called different things in different places, but hasn't been sort of swallowed whole cloth in Arizona. But help me understand why I'm wrong.
Sure, Judge. Well, obviously our members that are paying this illegal fee view the collection of a tax as it's a nuisance in that sense. It's a wrong. I think what the courts...
I was using it more in the technical
Sure.
sense.
The Henshaw case was actually to enforce private minority shareholders' rights. But I think that the main thing about it's not the cause of action that's really important here. It's the fact that it's done over and over again.
If that's the case, wouldn't the doctrine apply wildly broadly? And it hasn't been applied that way in Arizona.
Well, Your Honor, I would agree. It only applies in situations where you have someone who's continually violating a statute. I mean, if you looked at the Doe v. Roe case, they made the point, look, the accrual rule, the typical rule here is it applies for the typical case, the common case, single violation lawsuit. And that's true. Those are most cases. It's very rare we have a city such as Surprise that continually, and I briefed how they did this. I mean, they took money from one pocket and put it in the other and said they owe themselves money, which obviously is a fiction.
But would you agree that your analysis on continuing violation, if adopted here, would apply to any governmental agency that takes any action that's more than once, that's challenged as being violative of the law, that the continuing violation doctrine would apply per se to those?
Your Honor, I think let's take a look at the Mayer case, right? The Mayer case, the last bad act was in 1967 where the land commissioner wasn't collecting the fee he was supposed to collect. People sued 37 years later and said, I want my money because that was 37, they were doing this thing wrong 37 years ago. I mean, that's a distinction, or a taking case. The National Outdoor,
But
a
my
taking happens once.
My question, though, is a little different than that. Would you agree that if we adopt the continuing violations doctrine as you posit it here, that it would effectively mean any time a governmental agency takes an action more than once that's challenged as violative of state constitution, federal constitution, state statute, any other sort of regulatory or administrative or binding authority, that the continuing violation doctrine would always apply?
Judge, I would agree, yes.
And has, in the history of the state, though, is that the law? It doesn't seem to me that it is.
Judge, I think it most certainly is, because the continuing violations doctrine has been applied over and over again. It was applied in Builders Supply Corp.
Help me. In Arizona, that type of challenge happens with some frequency. Would you agree that the government action has taken action more than once in violation of some other obligation? That type of challenge, it's not maybe every day, but it happens with some frequency, and I don't know of any specific case in that context that's applied in Arizona, the continuing violations doctrine.
Well, Judge, we could not find a case that was precisely on point in that regard.
I feel better.
Maybe, though, because the continuing violations doctrine isn't even necessary to the analysis. I mean, the continuing violations doctrine seems to me to be a way of preserving an ongoing claim arising from what is essentially a single act. When you're talking about the government acting in violation of the law, why do you need a continuing violation? Why don't you just have multiple separate violations?
Well, Judge, I agree with you. That's also the case here. We have multiple separate violations, and however we want to characterize it, whether it's an exception. I don't think it's an exception. I think it's an interpretation of the statute of limitations that every single time there's a violation, there's a new cause of action, whether we call it continuous accrual or whatever we call it.
Is this? I'm still struggling with whether the statute of limitations is even relevant to a challenge to a law that seeks prospective relief only. If they impose a special excise tax on people with brown hair that is unconstitutional, and I pay it for 10 years, and then I finally get fed up and say I'm not going to pay this anymore, I'm not aware of any statute of limitations that would say I lose the right to bring up the academic question for prospective purposes about the constitutionality of a law I've been complying with. And so I wonder whether this entire discussion is simply on the wrong footing.
Judge, I agree with you completely, and I think that is our discussion. I think whether we label it, when you're seeking prospective relief, the statute of limitations, I mean, it's like the Pine Top Lakeside case, an action to remove a cloud from title. The statute of limitation never runs on such an action. I guess the way of saying that is the statute of limitations is inapplicable to a situation like that. I guess that's another way of characterizing it. The cases that have talked about it in terms of continual accrual, but I would agree. I mean, I don't even think you need to get there. I think every single time they collect this fee that the legislature says they cannot collect, I think they're doing it on an ongoing basis. I think that's kind of the beginning and the end of the analysis.
Or is it that the statute of limitations works to bar the claim of only someone with a certain factual basis for standing? In other words, you pay, let's say I'm just sort of a small-time developer and I pay the fee once and then I get out of the business. I can't bring that claim 3 years later, but if I pay the fee 1,000 times, perhaps I can. Is that what you're saying?
Judge, I think that anyone that's paying this fee on a regular basis or within the last year essentially has the right to sue to stop this. And maybe you're right. Maybe they don't even need to pay the fee. It could be someone else would have, just a private citizen would have standing. But I think the key thing is when we've got a government that is is violating the law on a regular basis, they plan on doing it in perpetuity, and someone brings a suit to challenge that, I don't think the statute of limitations was ever intended to insulate that conduct. I mean, I think that goes 180 degrees from the statute of limitations purpose. Statute of limitations is, okay, you did something that maybe it was wrong in the past, after you caused economic damage, but that happened, maybe it was a taking, like the National Outdoor case. They took property in the form of billboard regulations. But, that happened in the past. It's not ongoing. The law should not be permitted to inoculate an activity that's going on now. I mean, the Supreme Court in Havens Realty said it, the staleness argument disappears when you have an ongoing violation. We don't have faded memories or anything of that nature. So I would like to conclude my remarks because I'd like to have a minute for rebuttal if I could. So, but I'll answer any questions, obviously.
Thank you, Counsel.
Thank you.
Morning. Kirk Hayes on behalf of the City of Surprise. As I've read the briefs, I think there's probably three main issues that are on your mind right now that I'd like to address. One of those is, how do you balance the individual or an organization in this point's right to challenge a law versus the public policy reasons that underlie why we have statutes of limitations, which by definition extinguish an individual's right to pursue what they claim to be a meritorious claim?
In fact, Counsel, one of the things I was thinking about was the Municipal Claims Statute 12.82101. Counsel was saying that statutes of limitation are a bit wiggly, I suppose, when you start talking about a taking by the state and that kind of thing. But 12.82101, I think, has been pretty religiously enforced to say if you don't bring it in time, if you don't bring the claim, make the claim in time, you lose it, right?
Absolutely.
Though it hasn't been enforced religiously when it comes to prospective relief. And that's my concern, really, is whether the statute of limitations is even the proper framework for today's discussion. If one seeks prospective relief only, if the police come into my house and tear up the furniture and search it every day for 10 years without a warrant, are you saying that I can't get an injunction against that practice because it's unconstitutional in year 11?
No, Your Honor.
Okay, and what's the difference?
Well, I think that one of the difference, and going back to, I'm sorry, what you indicated, Judge Jones, is the public policy reason behind 12.821 and why it's there and why it's enforced. All statutes of limitations cut off claims.
Well, can I stop you there?
Yes.
The notice of claim statute, we know from Deer Valley, is there to permit considered judgment as to whether to settle a claim, right? I'm not sure how often that happens in real life, but that's why it's there. And this is a claim that can't be settled. This is not a refund claim. There's no money involved here. This is an academic question of whether the law is legal or whether it's not legal. The policies underlying the notice of claim statute have no application to this case.
I believe that they do.
How would you settle this case?
Well, not as a term of settlement, but as a term of there's a public policy reason that justifies the existence of putting a limitation on how long a person can bring a claim challenging an action by a municipality. That is something that's recognized over and over in the law. We put limitations on people's ability to bring claims.
But let's look at the nature of the challenge. If the nature of the challenge were, you charged me too much money and I want it back, then I would agree with you without further thought. But if the question is, you got to stop doing this because the legislature told you have to stop doing this, that seems to be an entirely different beast.
Functionally, from the city's perspective, it becomes the same thing. One, you want to end my ability to recover money, and the other, you want me to give the money back. Either way, it impacts the municipality's ability to govern its own finances. And by its own finances, I mean the finances of the public.
But surely you're not suggesting that nobody could bring this case if they've ever paid the fee, are you?
No, I'm suggesting that the Home Builders Association could have brought the case if they brought it within the period of statute of limitations.
But I'm saying now, let's say you have an independent homeowner, a renegade who's not part of the association. That home builder has been paying the fee since 2012 and suddenly looked up the statute and said, wait a second, I don't want to pay this fee anymore, and brings an action for future fees that it might pay, leaving the mistakes of the past to the side. Can it bring the action?
I think that the better example would be somebody who pays the fee for the
let's
first
use the
time.
worst example. Let's use my example
Yeah.
for now.
I think that if once you pay a development fee, then you're damaged under the statute of limitations as it's written by the legislature.
Let me restate the question. This is not a damages action. This is an action that says prospectively, I want you to stop violating the law. Are you saying that because, and I'm not suggesting that I have any opinion on the merits of this case, but when I phrase the question this way, but are you saying that because I let you get away with violating the law for the last couple of years, I now have to let you get away with it forever?
The way that the statute of limitations is written, the person has to bring the claim when they know that of the person who's being damaged.
It was a yes or no question. Can
And-
you address my question, please? This is the second time I've asked it. I'd like an answer.
No, I don't believe that they can bring a claim more than a year after they first had to pay the development
an
fee.
individual plaintiff loses his or her rights by allowing a violation to persist for more than a year and forevermore loses his or her rights. But a newcomer can bring the same case and create that right for the person who lost his or her rights. That sounds anomalous to me.
That would be a potential. But the
So
stat.
let me make sure I understand this. Let me give you a hypo. Year one, day one, I'm assessed. I don't challenge that for a year. And then year two, day 180, I'm assessed, and I challenge that year two, day 181. Very timely. Are you saying I can't bring that second claim because I didn't challenge the first assessment?
Yes.
Okay. I need help me understand that better.
Let me go into why I think that Judge Anderson decided that this constituted a single violation rather than a continuing violation, which I think may help answer that question. The continuous accrual doctrine is based upon the idea that there are continuing wrongful violations that occur, not that so you have a series of wrongful acts, not that you have a single wrongful act and then there are what one of the case said, the ill consequences that flow from that one single wrongful act. In order to be able to meet under the continuous accrual theory that they're asking that this court now adopt for municipalities, they have to have every single time that a development fee is paid, that constitutes a new wrongful assessment. And what I'm saying is that's not an assessment at all. The assessment is at the time when the legislature adopts the development fee. Development fee is different than a tax. Let me explain. I think the best way to explain this.
Well, but your briefs talked about that, didn't they? And how is somebody injured when that's just sort of floating in the air until it's assessed?
Well, they're injured because they immediately know what the damage is that they're going to face. In the Scottsdale,
Never assessed, which may never happen.
Yeah, what if I live in Baltimore and I come out here with the idea of building homes in Surprise? This law was passed 3 years ago. I'm not out of luck in my challenge, right?
well, but that's a different hypothetical than I was asked before, because there you're bringing in a person who has never been assessed the fee before. The prior question was, if you're assessed the fee once, are you barred from bringing it a second time?
Let me then refine the question. What we are dealing with here in terms of a request for prospective declaratory relief is not the enforcement of a personal right. It's the enforcement of a public right. So what does it matter whether there was a past violation that might bar one litigant when another can just as easily assert it? The statute of limitations are designed to eliminate individual claims that are private rights, not questions about public legality. I mean, I would ordinarily say constitutionality, but this is one rung below. So when it comes to the vindication of a public right, what's your best case for saying that prospective declaratory relief in a public setting is barred by the statute of limitations?
Well, I think that the national advertising case would be an example of that, because it's talking about the enactment of an ordinance that's then going to have an effect going forward. Also, the Scottsdale case, the Home Builders versus Scottsdale case, which gets to the nature of what the assessment was. This is a fee. It's not a tax. And that distinction is important because it means that the assessment occurs at different points in time.
But I thought you just said the assessment occurred when the ordinance was passed.
Yes. But for the continuing wrongful act theory to work, it has to be every time that it's paid. That may be true for taxes, but it's not true for a development fee. And the best example of this is if you look at the statute itself. The home builders are saying that the assessment occurs, and this is from their brief, at the precise moment of assessment is when the construction permit is issued. They have to have that because every single time a permit is issued, there has to be a wrongful act in order for continuing accrual to occur. But the best way to illustrate that that's not what really going on is to look at the statute itself. Every time that the statute, and it repeatedly talks about the assessment problem. Every time that it talks about the assessment process, it's talking about the determination of the development fee amount and where it's going to be used. This is a legislative function on the part of the city council. Every time they use assessment, they're talking about the process going by establishing what the fee is going to be. They have to give out notice, they have to have public hearings, they have to do all kinds of infrastructure analysis, they have to put it out as a proposal, and then they get it back. And then they determine the amount of the fee and who it's going to apply to.
Could they challenge the amount of the fee?
Well, that's a challenge.
Could they challenge that the assessment had been improperly done?
Yes. And they can do that within a year of when the assessment is made.
I think we may have different understandings of the word assessment. Assessment, it sounds like you're saying basically assessment is passage. It is enactment.
Under this statute, it is, and that's what makes it different than a tax.
We can call assessment, bread making or whatever. We can use any inapplicable term we want, but the concept remains the same. That you have to look at the date of, assuming we go with the limitations analysis at all, you have to look at the date of injury, and the date of injury is not the date of some abstract decision by a government body. The date of injury is the date that injury affects a person, is it not?
That's true.
So whatever we say assessment means, it for limitations purposes, it's got to be the date of injury.
Yes, because you're looking at two different concepts. One, you're looking at the violation, and the other, you're looking at the damage that arises out of it. Remember, for a continuing accrual, we need to have violations that would occur repeatedly, not that a damage continues out of the act. What I'm saying is this is where they claim the violation is, during the assessment process. That's when who is going to be assessed the fee and the amount of fee is determined. Every time in the statute it then refers to the collection of the fee, it uses a different term.
Well,
it never says assessment.
Who is going to have to pay the fee is never determined at that point.
The
class of people that might have to pay the fee is determined at that point, but who's in and out of that class, nobody knows, right? Nobody knows who's going to want to do business in Surprise. Nobody knows what buildings they're going to want to build until that actually happens.
You're right. And so the City of Scottsdale case that was dealing with this development fee and decided to treat this under a taking statute kind of analysis for determining when the cause of action accrued, one of the things that it looked at, or three of the things that it looked at, is what's different between a tax and a fee is a definitive amount is determined. Here, everybody knows it's $600 per development. And it applies to a large group, a class, not necessarily a particular person. But that class, the class of people developing their property, is defined. And there's no question about that. And then finally, its implication is standardized and uniformed with no discretion at the people who have to collect the money for the development fee. In other words, the assessment of the development fee happens at the time when the legislative body, the city, determines what the fee is and who it applies to.
So when the city imposes a monthly trash collection fee. That's a fee, not a tax.
Yes.
And the only difference, it sounds to me, between a fee and a tax under your analysis is that a tax has to be computed by reference to future facts.
No, it can be based on past facts, but it's computed on an individual basis. All of the tax cases that they're talking about require discretion on the part of the person assessing the fee, right? They have to determine the property valuation, or how much product was sold for sales, or what withholdings apply. All of those require discretion. A fee does not. A fee is a one-time event that applies to everybody. When you go up to the permit counter, you can't say, well, my project's smaller than somebody else's, so I should only have to pay a $300 fee. No, it's determined and set legislatively, and it's the legislative body that did a single act. In that way, this fee is different than all of the tax cases they talk about, because all of them involve determinations that are ongoing. It's also different in this sense. All of those, in order to avoid the accrual issue and when that is, they have statutes that define when that accrual would be. Here, the act that they're claiming is wrong was by the legislature, not by the people collecting the fee.
But
and that's
we
why
see all the time, though, that a wrongful act doesn't trigger the statute of limitations until it results in known injury.
Exactly. And that's one of the things that the Scottsdale case said. It says we know the injury because it's a fee as soon as it's passed and it goes into effect. They said a prospective developer may know precisely the fee that they will be charged. That's what in the national advertising case they said an enactment of something that's subject to these takings type of accrual analysis has a property interference that was in a clear and concrete fashion when it was passed. There's no question at all in anybody's mind about who is involved or what fee they will be charged, because it's set a single time at the moment of that it's put into place.
It sounds to me, though, like you're treating the statute of limitations as if it were a statute of repose. That once the wrong is done, there's a certain amount of time, and forevermore that wrong gets to stay in place. And there is a difference between those two types of statutes.
There is, and I see where the confusion might come from my argument. Remember that you require two things with a continuous accrual, or an accrual. You require the violation and you require the damage. It doesn't become a statute of repose because the damage may occur at some later date for that particular person, the person who really should be bringing this case instead of the home builders. The home builders as an organization had people, and they knew, and they were damaged when it was passed. And the first member was assessed its fee. It then has imputed knowledge concerning it. Somebody else may have a cause of action at a later time.
And
But
Counselor, when you use assess there, you mean it more in the lay sense than in the argument under your statute, correct?
I do,
Okay.
yeah. Because the argument under the statute is it's the legislative act that's the violation. We don't have that legislative act every time that somebody collects the fee.
Right.
And the statute never intended it to be viewed that way. That's why it's so careful to use paid versus assessed. There are other opportunities for it to be challenged as well. These development fees come and go in existence. They need to be modified. They need to be amended as different things happen and different financial problems occur for the municipality. And so every time that they're amended, they can be challenged on the basis of what those are. Or August 2014 was a requirement that action needed to be taken on the development fee. At that point, it starts a new 1-year period, because that's when the legislature, the city council, takes its action to determine what the fee would be, and that's when the violation would be occurring.
But what relevance does that have to the accrual date?
Well, I think it goes to the idea that this somehow creates something that can never be challenged, and that's simply, as a practical matter, it's not the case at all.
Well, in fact, it can almost always be challenged, correct?
Anytime that within a year of whenever the legislature makes a change, or within a year of when somebody is damaged for the first time.
For the first time.
Yes.
I understand the position.
The next question is should we adopt the continuous accrual for municipalities. And that's a question of whether or not a judiciary body, whether this court or another one, should graft into a defined definition of accrual by the legislature a principle that isn't reflected in the language. Here, accrual is statutorily defined. It's in 821.01, and it says exactly what accrual is supposed to mean. Now, they make the claim that that incorporates all of common law on doctrine on accrual based on a case, the Stalouse case, that said that the 12821 is the codification of the common law. But that's not what it said at all. It's the codification in this sense. The legislature included the discovery rule in how it wrote the statute. So it's based on when you knew that you were damaged, not when you were actually damaged. But it didn't incorporate everything. For example, look at the city of Tucson versus the Clear Channel. The common law rule was you either knew you were damaged or should have known you were damaged. So Clear Channel argued, well, should have known you were damaged should have also been incorporated into 12821. And the court there said no, because the legislature didn't include that language in its definition of accrual. It declined to read it in. The same principle applies here. If the legislature had intended continuing accrual to apply to a claim against a municipality, it should have written that language into the definition. It didn't, and it's inappropriate for a judicial body to do that.
Thank you, counsel.
Thank you.
Counsel.
Thank you, Judge. The legislature did not define accrual in 12-821. This is 12-821. It just says cause of action accrues 1 year and not thereafter. And Clear Channel and also Anson say that when the legislature uses the term accrual, the courts interpret that under common law principles, because that's been the way it's been in Arizona for years and years and years, and legislature knows that. The 12821.01 is merely a codification of the common law. Stoolsay stated that. Also, on the notion that the act is when the fee was adopted, that's just not the case. They continue to misstate our complaint. We say we want an injunction to stop them from continually assessing the fee, a declaration that the fee can't be assessed. If we look at the statute, the 463.05K, a development fee that was adopted before January 1st, 2012 may continue to be assessed only to the extent it complies with the statute. Notice the juxtaposition of the word adopted for the ordinance and the fee is assessed. Those are two entirely different words. Assessment is the triggering point, and that's when they demand money for a housing permit.
You're out of time.
I'm sorry?
You're out of time.
Can I make one more point?
Go ahead.
It's interesting that they now say we could challenge based on the requirement in law that they readopt impact fees on August 1st, 2014, because they took the opposite position of that in the trial court. We briefed that. We said, Judge, even if we miss this statute of limitations, the law requires them to adjust the statute of limitations on August 1st, 2014. And the judge said, no, it doesn't matter. So that is entirely different from the position they took at trial court. I don't think they've readopted the fee as the law requires there either. So with that, thank you.
Thanks. We're going to take it under advisement at this time. Counsel, we do appreciate your argument, and we will be issuing a written ruling in due course. Thank you.